Welcome to another episode of National Divorce Talk Raw. Well, today we're going to do an update. Now, we've covered how certain professors have said that secession is legal. And now we had another professor add on to it. So now we have three top legal professors who have said publicly that secession is legal. This is in contrast to most of the newspaper articles that you're going to hear. They're going to say secession is completely illegal. We're going to show you the three professors that have said secession is in fact legal, what they said, when they said it, and why you should believe them. Something the mainstream media will definitely not cover and point out to you. And we'll do that all in 1 second. Welcome. This is going to be a straightforward episode. So there was this case, Texas versus White, 74 U.S. 700, decided in 1868. And what they said was secession was illegal, but they meant unilateral secession, meaning you just take off. In that document, Texas versus White, and this is the only Supreme Court case that ever mentioned secession throughout the entire history of the United States, they say secession could be legal through revolution or, quote, consent of the states. Unilateral secession is illegal, according to Texas versus White, the only case of its kind on secession. But secession with consent of the states could allow secession, according to this. There are three law school professors who now agree with that interpretation of the famous Texas versus White case. We will get to that in a second, but let me show you all the background, and then I'll show you exactly what they said. So this is the actual case, Texas versus White. And this was the only case ever decided by the Supreme Court that mentioned secession at all. And what they say is that one second here. I just had it. Constitution, all right, here we go. Okay. The perpetuity and indissolubility of the Union by no means implies the loss of distinct and individual existence or the right of self-government by states. On the contrary, it may be not unreasonably said that the preservation of the states and the maintenance of the government are as much within the design and care of the Constitution as the preservation of the Union and the maintenance of the national government. The Constitution, in all of its provisions, looks to an indestructible union composed of indestructible states. That is the quote you're going to hear mentioned a lot in the media. The quote you're not going to see mentioned in the media is this one right here. There was no place for reconsideration or revocation except through revolution or through consent of the states. So you're going to see this quote right here mentioned a lot. Texas versus White says you can't secede. Here's the exact quote. The Constitution and all its provisions looks to an indestructible union composed of indestructible states. You'll see that quote a lot. Here's another quote also in that legal document that you will almost never see in the press. There was no place for reconsideration of if you could secede or revocation of a law preventing you could secede except through revolution, which they had to admit because that's what they did in 1776 against the British. That was a secession movement, not an independence movement. And or through consent to the states. Consent to the states was never defined. It's just, hey, if you got consent to the states, whatever that means, then you could legally secede. Well, here are the law school professors. We're looking at Eugene Volokh, the Gary T. Schwartz Distinguished Professor of Law. He clerked for Sandra Day O'Connor on the U.S. Supreme Court and was on the U.S. Court of Appeals for the Ninth Circuit. He teaches First Amendment amicus brief clinics at UCLA. So here's this UCLA professor, Eugene Volokh, and he clerked for the Supreme Court and worked on an appeals court. Here's another person, Erwin Chemerinsky. Erwin Chemerinsky is the dean at Berkeley Law and a distinguished professor. Prior to assuming this position, he was the founding dean and distinguished professor of law at Irvine. So he's the dean of law at Irvine, and he's the dean of law at Berkeley. And in 2017, he won the National Jurist magazine, again named him for a second time the most influential person in legal education in the United States. So he has won awards as the best legal mind in 2017, and he's been the dean of 2 different California law schools. The other person is Cynthia Nicoletti. She's not a Californian. She's University of Virginia School of Law, but here's her curriculum vitae. She was the senior editor for the Harvard Journal of Law and Policy. Guess who else was the senior editor for the Harvard Journal of Law and Public Policy? Barack Obama, who became president. So, not too shabby. Senior editor for Harvard Law's Journal. Now, here's what they all said. Here is Nicoletti. States can't unilaterally secede from the U.S., she told Newsweek. This was established both by the outcome of our Civil War and by the Supreme Court in the 1869 case Texas versus White. Article 1, Section 10 of the Constitution also prohibits states from entering alliances, treaties, or confederations. I suppose theoretically it's an open question as to whether a state could secede within the consent of Congress or within the consent of the states. It's an open question because it hasn't been defined. There's some throwaway language about the possibility of all states agreeing to allow one state to secede in both Abraham Lincoln's first inaugural address and in Texas versus White. So Abraham Lincoln himself, the president who fought to keep the Union together, said there was a possibility for legal secession through consent. Texas versus White, the only Supreme Court case on secession decided after Lincoln died, also backed up Lincoln and also said secession could happen with consent. So Abraham Lincoln said it, and the Supreme Court, stacked with people he appointed, said it after he died, right after he did. And that's what Nicoletti is saying, is that it could be a simple consent of Congress could allow you to secede, because there's this phrase, consent of the states. So simple consent of Congress could qualify for consent of the states. That is what Nicoletti said. And here's the article that it came from. Okay, this is Erwin Chemerinsky. Since we've never been there, we don't know. We don't know. We don't know. In theory, because it was a majority vote of Congress to admit California, in theory, majority vote of Congress could approve secession. We don't know. We don't know. Open question. Erwin Chemerinsky. Simple majority vote of Congress could admit California. Let's go back to Nicoletti. It's an open question. Remember this guy, we don't know. Open question. See, we don't know. One law school professor, we're not sure how to interpret consent to the states. Here's another law school professor saying it's an open question, but it could be a simple consent of Congress would allow you to secede. In theory, it could be a majority vote of Congress. So literally saying the same thing. Not exactly sure. Could be a simple majority of Congress. That's what Erwin Chemerinsky said. That's what Nicoletti said. Here's the article that Chemerinsky said that in. Okay. Well, secession movement's still going, but I guess you weren't here with Roe v. Wade 5 years later. Anyways, here's the next article. That doesn't mean it couldn't happen, says Eugene Volokh, a law professor at UCLA who's written extensively about political secession. A state couldn't legally force the U.S. to let it secede if the U.S. refused. But if the state and the U.S. agreed, that would be doable. At worst, it would require a constitutional amendment at worst. But most likely an act of Congress. So, most likely, guessing, not sureable, at worst, not sureable, But it could be a simple majority vote of Congress. That's what Eugene Volokh says. Possible simple majority act of Congress. Eugene Volokh. That's also what Chemerinsky said. That's also what Nicoletti said. And here's the article where Volokh says that. Here's why I text it, hashtag text it can, but won't happen. So let me show you the exact quotes. Erwin Chemerinsky, in theory, simple majority vote of Congress could allow you to secede. Erwin Chemerinsky, dean of 2 law schools. Here is the quote from Eugene Volokh. But if the state and the U.S. agreed, it would be doable. It may require a constitutional amendment, but most likely a simple act of Congress. That's what Eugene Volokh, a professor at UCLA Law, says. I suppose it's theoretically an open question if you concede with just the consent of Congress. There is some language in Texas versus White that makes it seem like you could secede with just a simple consent of Congress, and that would qualify as consent of the states. That's from Cynthia Nicoletti, professor of law at the University Law School. So I just showed you the 3 articles where a law school professor says Texas versus White could be interpreted in the phrase consent of the states to mean a simple majority vote of Congress. 1 article, 2 article, 3 articles. Here are the professors who are saying that, very distinguished professors. And they're talking about this case, and they're specifically talking about this phrase. The Constitution in all its provisions looks to an indestructible union composed of indestructible states. There is no place for reconsideration or revocation of that except through possibly consent of the states. So these professors are interpreting what the phrase consent of the states means, found right here. And what they're saying is that particular phrase in this only Supreme Court case on secession could mean a simple majority of Congress. It does not have to mean a constitutional amendment process. So wanted to make sure you got all those facts, because nobody will report that and point out that there are a lot of legal minds who say a simple majority vote of Congress could be all that's necessary for legal secession, according to the only Supreme Court ruling on that. Nobody's pointing that out. What you're typically going to see is people go, well, there was Texas versus White, and it said you can't secede, end of story. They won't mention the second sentence. And then they won't mention that multiple professors who are highly respectable have said this could be interpreted as a simple majority of Congress. And the fact is, there's only one group of people who get to say what consent of the states means, and that's the current Supreme Court. So if the current Supreme Court interprets consent of the states to mean, according to Texas versus White, a simple majority of Congress, then that's what it means. Period. End of story. There's nothing you can do about it. If the conservative Supreme Court interprets consent of the state to mean, oh, constitutional referendum, then that's what it means. End of story. So we don't know until the Supreme Court revisits this issue. But I wanted to point out 3 reputable legal scholars all have said a simple majority of Congress could be all that's necessary for California to legally secede, according to the only federal law that discusses this. Okay. We'll see you later. Thanks for stopping by.